Hi there, this is Kaushik Ranchod from the Ranchod Law Group. Welcome to our immigration show. Today I'm going to talk to you about 5 myths about the I601A waiver that you'll want to know. So watch till the end. Smash that like button if you like this video, and let's dive into it. So I601A waiver. First of all, what does it do? Well, if you enter without a visa, it's going to allow you to overcome something called unlawful presence, where if you left the United States and you entered without a visa, you'd be subject to either a 3-year or 10-year bar, depending upon how long you stayed in the United States. So let's talk about the steps in the process. So the first step before you even get to the I601A is having the I-130 petition filed. Typically that would be filed either by your spouse or your parent. That's what we see most of the time. And then after that, we file for the I601A waiver. Once that's approved, you move to the National Visa Center processing. That's where you have to prove, the U.S. citizen spouse needs to prove that they can meet the affidavit of support requirements, the public charge requirements. The DS-260 is completed, and we submit other documentation as well. And then finally, you're scheduled for the interview. So that's the process in a really fast nutshell. So now let's dive into what the 5 myths are. So myth number 1 is, does getting the I601A waiver, going through the process, provide you with work authorization? This is a really good question. It can be really confusing because a lot of times when I have a consultation, people will say, well, I know so-and-so and I know so-and-so who got their work authorization while they're applying for a green card. Well, that's a different process. That's called adjustment of status, where you come into the United States with a visa, and then you may be eligible to apply for adjustment of status within the United States because you entered with a visa. And if you are filing with an immediate relative, this is the most common form of filing for the green card within the United States. So an example of immediate relative would be the spousal green card. So in that situation, when you file for an adjustment of status, you can get work authorization by applying for the work authorization with the green card application. And typically that does take some time before you're able to get the work authorization, but you are able to get the work authorization, and those times depend upon the government processing times at the time. So let's get back to the myth here. Well, the I601A waiver process isn't like the adjustment of status process, where it affords you the right, where it gives you the right to get work authorization during the process. But once you enter on the immigrant visa, once you get the actual green card, that of course gives you work authorization, gives you the right to travel, and you're here as a lawful permanent resident. All right, that's myth number 1. We made some progress here. Myth number 2, can I leave the United States while my waiver's pending? Well, what we recommend is that this is in contrast to the I-601 waiver. So let's back up here. We've been filing the I-601A since it was created by the Obama administration, since it was introduced by that administration. And the reason it was created is so that the I-601A can be applied, the waiver application can be applied in the United States, whereas the I-601 is only applied after the immigrant visa is denied. So with the I-601, you go in and you have the visa interview, and then at the visa interview, they deny the application because you're subject to the ground of inadmissibility, the most common one being the 3 or 10-year bar. Then you apply for the waiver. And so that's a whole long drawn out process, whereas the I-601A, you can apply in the United States, so you don't need to leave. And that's the whole purpose of the I-601A, is you can apply for that in the United States. So the most common question, one of the most common questions we get is, well, how do I minimize the time outside the United States when I'm going through this waiver process? Well, you'll get an interview notice date, an interview schedule date, so then you'll know when to go to the interview. So what I recommend is that if you want to minimize the time outside the United States, you wait till you get that interview notice date. All right, on to myth number 3. Am I in lawful status while the waiver's pending? So filing for the waiver application does not provide a lawful status in and of itself. So, however, once you get the green card, once you enter on an immigrant visa, you get the green card, of course, that's the lawful status. So that's why I recommend that you apply as soon as you can, so you can try to get a lawful status for yourself, try to get a green card so that you no longer are in lawful status. And myth number 4, I can get my green card without leaving the United States. This is another common myth where people are getting confused, where you might be getting confused with the fact that people are getting the green card in the United States by applying for adjustment of status, again, as I mentioned earlier, where the person entered with a visa, entered with inspection, and then they can apply in the United States, so they don't have to leave. But what the waiver is doing is it's forgiving the fact, overcoming the fact of the unlawful presence. So in this situation, procedurally, what you have to do is you have to leave the United States because you're doing what's called consular processing with the immigrant visa, and you're applying outside of the United States. So you will have the final step, the visa interview outside of the United States at the appropriate embassy that pertains to you. Myth number 5, I cannot contact an attorney until I have an approved immigrant visa petition. So while you need to have an approved I-130, it's recommended that you work with an attorney from the beginning of the process, because that way you can create an outline strategy that is consistent all the way through the entire case. So you can start from the very get-go with an attorney. You may want to consider obtaining someone who focuses on I601A waivers. And what we like to do in our cases is prepare a legal brief outlining all of the hardships that you may have and creating and outlining based off of your unique factors what those are in that legal brief. So I hope this video provided some value to you, and you can subscribe to continue to get this kind of information. And if you haven't already, smash that like button. And thanks for tuning in, and we will see you next time. Thank you and have an amazing day.